Michael Sheehan is a Denver-based attorney who graduated from the University of Colorado at Boulder and got his law degree from the University of Denver. He has been specializing in criminal defense ever since graduating from law school. Michael Sheehan is board certified in criminal defense trial practice by the National Board of Trial Advocacy. He is a member of the American, Colorado, and Arapahoe County Bar Associations and a former board member of the Colorado Criminal Defense Bar. Michael, thanks for being here.
Thank you for having me.
What do you think made you lean towards defense?
I've never been all that comfortable pointing the finger at other people or singling people out who have made a mistake or done something wrong. I've always been more comfortable having somebody's back and kind of like being in that underdog role. I know it's a bit of a cliche, but I growing up found myself more sort of aligned with the underdog. And after finding out that I could do that for a living with a law degree, it just really appealed to me.
Yeah, I mean, personally, I'd find it hard to put people away for life for a long time, especially when you just don't know in a lot of cases.
Right. I mean, a prosecutor, I've never been one, but my observation over the past 20 years has been that they do what they can with the information that they have available to them, and that they at least most of the time think that they're doing the right thing and that they've got the right guy or girl that they're trying to convict for whatever it is the crime is that that person has been charged with. But you make a good point. It's very difficult to know anything 100% or be sure of anything. Um, and I would just be real uncomfortable, accusing somebody of a crime or of making a mistake that I couldn't prove beyond a shadow of a doubt. And I know that's a lot higher than the legal burden in a criminal case, which is proof beyond a reasonable doubt. Shadow of a doubt's even higher. But if I wasn't able to meet that type of burden, I'd have probably a difficult time sleeping at night.
Yep, I agree. What skills make for a really good criminal defense attorney?
I think good listening skills are essential. I think patience is critical. I think you, as a criminal defense lawyer, you you have to be willing to go to trial on difficult cases, which means you can't be afraid of losing. And that doesn't mean you have to like losing. Nobody likes losing. I don't like losing, but I need for the prosecutors who I go up against to know that I'm not afraid to lose. Because if I was afraid to lose, then they would know that if I told them my client wanted to go to trial, that it was just a bluff, that I really had no intention of ever trying the case because I was afraid to lose. The prosecution decides which cases get filed and which ones don't. So they should never lose, in my opinion. And if at any point during the course of a case they determine that the facts aren't what they originally thought that they were, and suddenly the facts are becoming more favorable to the defense, they could always choose to dismiss a case at that point before it goes to trial. But if a prosecutor has committed to trying a case, they should win it. And again, that's kind of gets us back to the whole underdog, uh, you know, role that a defendant and a defense lawyer have in a criminal case. And you'd be surprised at how many defense verdicts there are in criminal law. The defense wins, I would say, more than their fair share of the time. But you wouldn't know that if you were afraid to try the case in the first place. And that's why, in my view, the best criminal defense lawyers are the ones that are fearless, that they've not won every single case they've ever gone to trial on. They've lost a few. All experienced trial lawyers have, but they live to fight another day. They know that it's not the end of the world if you lose. Doesn't mean they like it, but it it makes them a better trial lawyer. They learn a lot in the process, and they prove to the prosecution that they're not afraid. And it's really the 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 jury trial is the most leverage a defense lawyer really ever has when it comes to trying to negotiate a dismissal or a fair settlement for their client. Like I said, if a prosecutor knows that it's just a bluff, then the defense has no leverage at all. But if the prosecutor knows that the defense attorney can, walk the walk instead of just talking about it, then that is some leverage for the defense to use because the prosecution knows they actually have to prove the case beyond a reasonable doubt.
You've been a criminal defense attorney how long?
Almost 20 years.
Almost 20 years. So I'm imagining you start with things like probably going to do a lot of DUIs, and then eventually you're going to get into more serious things like murder or stabbing, something like that.
When you start, you handle misdemeanor cases, which consist of lots of DUIs, lots of low-level domestic violence cases, and sort of minor assault cases, sometimes theft cases, um, sometimes low-level drug possession cases. And back when I was coming through the public defender system about 20 years ago, you usually spent about a year in the county court before you moved up to the district court. And when you get into district court, you're handling serious felony cases, everything ranging from serious drug cases to serious assaults, sexual assaults, homicide cases, um, major child abuse cases. So really the heavy lifting happens in district court. But the idea is that when you're in county court, you should be trying as many cases as you can to get experience that will benefit you and your clients as you move up to district court and start trying the more serious cases that have mandatory minimums attached to them. Like, for example, an assault case with a mandatory minimum prison sentence of 10 years if the defendant loses at trial. So there's high stakes and heavy consequences attached to that type of a case.
How do you fight DUIs?
Well, what you do as an attorney that gets retained on a DUI case is look at all the police reports, look at any body camera, audio or video files that come across your desk related to the case, and you look at the case for anywhere between six and 10 different things or different ways that a police officer might make a mistake in a case like that. There's not really anything that a person, no foolproof way on the front end that a person has to avoid getting charged with a DUI or DWAI. If a police officer finds probable cause, a person's likely going to get charged. But on the back end, after the charges have been filed, like I said, there's a handful of important things that a police officer has to do correctly. Otherwise, the case could get thrown out.
So what are some of those?
So a couple of things that an officer needs to do correctly are give a person the proper advisement when it comes to doing a blood or a breath test. If the police officer botches that advisement or makes it confusing to a person who has to make that choice, that could be a basis to suppress some evidence in a DUI case. Another thing that the officer has to do is make sure that a blood or breath test is done within a reasonable amount of time. The police have to make sure that if a person takes a breath test, that the machine that measures a person's blood alcohol content is functioning properly and isn't glitching, for lack of a better way to say it, and make sure that the person operating it is certified and properly trained to operate it. Those are just a couple of things, and there's more, but those are a couple of things that a good defense lawyer is looking for in the reports that the lawyer gets.
I feel like people are put in kind of an awkward position if they've had a few drinks and, you know, you don't want to lie, but at the same time, you feel like if you say that you've had a few drinks when you've been pulled over, you you figure that you're probably going to have to, go through further questioning. And so, if someone has had a few drinks, is it best for them to be honest about that?
You never want to lie to a police officer because that's a whole new set of problems if it can be proven that you're making a false report to a police officer. But if you tell a police officer that you've been drinking, that goes a long way to helping that officer establish probable cause. And once the officer establishes probable cause, then that person is expected to take a blood or a breath test. And if the person takes a blood or a breath test and the blood alcohol content comes back over the legal limit, you've got a very difficult case to defend. So if there's a way to avoid answering the question, that would be more advisable than being dishonest with a police officer.
It's funny you said that. I talked to a guy, I think he was a former cop. And I said to him, if you had been drinking at all, what would you do in that situation? And he said he would barely roll the window. I mean, this just sounds a little extreme, but he would barely roll the window at all and would not say one word to the police. He would simply hand them what they asked for, and that's it. He would not say a word when they asked him a question. I mean, that's going to make you pretty suspicious.
Yeah. Yeah. I've heard of people who have tried to take that approach when they're stopped for DUI. It doesn't happen very often, but I've heard of a similar approach before. Not with one of my clients, just anecdotally. As I recall, it didn't work out quite as well as the driver expected it to, for the reason you point out. It's highly suspicious behavior, and I wish it were that easy, because if it was, people like me would have a real easy time advising clients and prospective clients how to avoid ever getting charged in the first place with a DUI or DWAI. But in theory, it sounds like a good strategy, but in practice, I'm not sure it's all that effective.
I'm going to give you another one of those. This was an old story or joke somebody told me a long time ago. I never forgot. The idea was that if you ever get pulled over, what you do is you keep a bottle of alcohol with you. And when the cop gets up to the window, you start chugging the bottle right in front of the cop. And now the idea is, how can that cop prove that you didn't start drinking right there?
Yeah, that's another one that gets talked about. And in fact, if if a if a defendant can put on some evidence that they drank after they were stopped or discovered to be operating the motor vehicle, if they can put on some evidence that they ingested alcohol after the fact, it does create an affirmative defense for the defendant in a case like that. But I think that a good prosecutor would point out to a jury that the only reason that a person would pull out a bottle and start drinking in a cop's face like that would be to try and pull one over on a jury. So I'm all about creative ways to do these trials and to litigate these cases. But I think that a good prosecutor might figure out a way to turn that one around on a defendant and just make it look like a real desperate attempt to pull one over. And I'm not sure that at the end of the day it would be a winning defense. But interesting idea.
And what about should people take the what do you call it? The breathalyzer, or the one where you have to do all the things?
Voluntary roadsides.
Yeah, should they do the roadside? Should they do or should they do a breathalyzer, or should they refuse and do a blood test, or should they refuse them all?
Well, the voluntary roadsides never really help anybody out, and The police usually do make a point to tell people that the roadsides are voluntary, but I think that that word voluntary tends to go in one ear and out the other, because I'm always surprised by the number of people that agree to do them. They're difficult to do. And what happens is when people attempt to complete them, they give the police more probable cause, more evidence to use against a person at trial, when really, by the time a police officer gets around to asking a person if that person wants to do roadside maneuvers, the police officer has usually already decided that they're going to arrest that person for DUI. That decision has typically already been made. And even if the person refuses to do voluntary roadside maneuvers, the officer is going to ask that person to do a blood or a breath test. And the refusing the blood or a breath test, I suppose, might be a good decision in cases where somebody's BAC is very, very, very high. There's no way to know what a person's BAC is unless you measure it. But in cases where a person's BAC is going to be real high, I've seen people benefit from not taking the test, but not taking the test has consequences, both with the DMV and with a district attorney who you're trying to negotiate with, because the district attorney will more likely than not jump to the conclusion that you refused the test because you were at minimum you were above the legal limit, and you were possibly way over the legal limit. So you have to deal with that inference, which is going to get drawn by the DA and potentially get drawn by a jury at a trial if a person ends up in trial. And that's why if a person suspects that maybe they're driving under the legal limit, and the legal limit for DUI is 0.08. So a person who's maybe just had one drink that thinks, well, I don't think I'm above that legal limit at this point, they shouldn't refuse the test, because a refusal, like I said, is going to create certain inferences with everybody from a DA to a jury to a judge, and they're going to think, well, the only reason if you weren't drinking too much and driving, you would have agreed to take this test.
And,
so
and don't you automatically lose your license for like a year?
For a refusal,
Yeah.
yes, you do automatically lose your license. Typically, it depends a lot on a person's driving history, what the length of time is going to be when it comes to that revocation. But typically, a person can get their license back. It's called early reinstatement after serving a month of the revocation with no driving. And there's some requirements that a person has to comply with before they can get their license back. But usually after 30 days or so, a person can get their driving privileges back, but they're restricted. The exception to that is with a refusal case. If a person refuses the blood or breath test, then they have to wait at least 60 days before they can apply for early reinstatement. So there is a built-in, I guess, added punishment built in when it comes to refusal cases.
And do you think people should take should refuse the breathalyzer and go for the blood? Because it takes longer. You're going to get more time before you can get over to get the blood done.
Well, I see what you mean. You really, the requirement that is on the police is that they get either the blood test or the breath test done within 2 hours of a person driving their vehicle. And typically getting a blood test or a blood draw within 2 hours is not a problem. That's something that the police are used to doing and used to having done. And it's rare. It does happen sometimes, but it's kind of rare that it would take longer than 2 hours to get a blood draw.
Oh, that's not what I meant. Well, I meant if somebody says I'm not going to do the breathalyzer, let's do the blood, because by the time you take me over there, it's going to go down.
Mm-hmm.
The breathalyzer, it's going to read me right now. It might be an hour, and it's going to go down by the time the blood does it.
Well, There's usually a little bit of lag time, regardless of whether you're doing a blood or a breath test, because
Oh, okay.
the breath test is typically going to get done at the police station. So there's going to be a 15 or 20-minute drive to the police station.
Okay.
A lot of times the blood test is done at a hospital. So there's going to be a 10 or 15-minute drive to the hospital as well. I think, one difference between blood and breath is that I think that most people who get involved in these cases as judges or lawyers, and even jurors, tend to think that blood test results are more accurate than breath test results. Um, there is a right that the defendant has to have the blood test, the blood sample retested by an independent lab. And I always encourage my clients to do that. But more often than not, the independent lab comes back with results that are identical to the results that were generated by the Colorado Bureau of Investigation. So the blood test results tend to be accurate with less margin for error. There is some margin for error on a breathalyzer. So if a person is right there at the legal limit, a lawyer might have an easier time convincing a jury or a prosecutor or a judge that the defendant should get some benefit as a result of that margin of error.
What should people do or not do when being pulled over?
Well, I think it's always a good idea to be polite, and not be combative or hostile with the police officer. Um, that's just I think that's just a good rule for any contact with the police in general. That doesn't mean you have to consent to do everything that they want you to do, and a person shouldn't be willing to consent to do everything that an officer wants that person to do. But a person can still be polite. I just don't see that there's really much to gain by making what's already going to be a stressful situation even more tense and stressful by creating um, you know any kind of conflict with a police officer who's in contact with you.
Should you answer the police questions?
I would say no. I mean, as a general rule, there are very few questions that a person has to answer. A person is expected to tell a police officer what their name is, but when it comes to questions that are related to the police officer's investigation, regardless of the kind of case it is, a person doesn't need to volunteer that information. And people talk a lot about Miranda warnings and the Fifth Amendment privilege that we all have. That typically doesn't kick in until a person is in custody. So Miranda warnings have to be given when a person is being interrogated and they are in custody. And there's a whole lot of case law in Colorado and around the country that helps determine when a person goes from being out of custody to in custody, and when questioning goes from just sort of the preliminary types of questions to an interrogation. So these are things that get litigated all the time in all different kinds of cases all over the country. But what I wish people knew is that they're not going to get a warning from the police. Assuming the person is out of custody, they're not going to get a warning from the police that the police is starting to ask questions that are designed to incriminate the person, the suspect. Those types of questions can happen right away, early on in police contact. And luckily, these days, most of the police contact that happens here in Colorado is on body camera video. So it's all recorded. And if a person had the wherewithal right away during a police contact to say, hey, I don't want to answer that, I think it would benefit a lot of people that end up getting in trouble and having to try and dig their way out of it on the back end.
Here's one you see a lot. Cop asks you, If you have anything in your car they should know about, just be honest and I'll work with you.
Well, the police are allowed to lie to people, and I'm not here to badmouth all the police in Colorado or anything like that. I would never do that. But I've seen many, many, many examples of the police making promises to people that they never had any intention of keeping, and it was all part of the investigation, that they would lie to a person to keep that person talking or to get that person to admit to something that the police suspected to be true. So it's never a good idea to trust a police officer who says that. And I don't mean to sound so cynical. I know that's how it sounds, but when you see it over and over and over again, you just can't help but learn that that's a tactic that is used by the police all the time. And it's effective because there's a certain type of person that believes that the police are going to shoot straight with them, and that they have no reason not to trust a police officer who is telling them that they're going to do them a favor. Every once in a while, I'm sure there are police officers that do people favors when that person is candid and honest with them. But I don't get to see those cases. Those are the ones that don't get filed. So I don't have any real experience with the good outcomes that might happen, after a police officer says something like that to a suspect. I only see the bad outcomes.
So even if you haven't done anything wrong, are you consenting to search?
It depends. It really depends on all the circumstances. My knee-jerk reaction is to always say no. But I suppose that there are some circumstances, and there might be some instances where it really does pay to consent to a search or to consent to an interview. But it would just depend. And I'm like most criminal defense lawyers who have been doing this kind of work for a while. The knee-jerk response is always no consent, no statements, don't agree to a search. Because when you start talking and when you let a police officer search your car, your house, whatever it is, what you're doing is you're helping the police and the prosecution check the boxes that they need to check. In the first place, to arrest you, and second, to convict you if you ever end up in court. So that's why the knee-jerk reaction to your question is always no, don't consent.
What do you say to someone who says, look, if I didn't do anything wrong, I have nothing to hide, I have no problem talking to the police?
The problem is that your typical person, even somebody who has training as a lawyer, can get twisted up during a conversation with the police. They can say things that get misunderstood or get taken out of context, or they can misspeak. They can make what they think might be an innocent mistake in the words that they choose or the way that they phrase something. And once that statement that has been taken out of context gets written down in a police report or passed along to another officer or passed along to a prosecutor, it's way too late to correct the mistake. And that happens a lot with people who are younger, people that don't have experience talking to a police officer and get nervous. But it could just as easily happen to a middle-aged person. And like I said, it happens to people like lawyers who talk to police officers all the time. So it happens. It's a very real problem that a person makes a statement that at the time seemed pretty innocuous, but gets twisted and used against them and forms the basis for some type of criminal case. So the safe way to handle that situation is to say nothing. That way you can't be misunderstood. And the law protects a person and says, that person has the absolute right to say nothing. You can't hold their silence against them. Those are the rules. That's what the Constitution says. So it's a much easier way. It's much easier to defend a person who has said nothing than a person who attempted to talk their way out of a problem, because usually that person that attempts to explain and tell their side of the story, they start off by establishing that they were at the scene of the alleged crime, which is one of the elements that the prosecution has to prove in a criminal case. And without meaning to do it, the quote unquote suspect has just checked that box for everybody, because they've said something like, well, I was there, but it's not what you think it was. Had they said nothing, the prosecution might not even be able to prove that the person was even where they were alleged to have been.
I told a police sergeant that I was talking to a criminal defense attorney and for the podcast, and he said he thinks that they serve a purpose, but he doesn't like how they often manipulate facts to serve their clients.
I'm sure that this sergeant has been a witness in lots and lots of criminal trials, obviously been associated with probably thousands of criminal investigations, but the facts are what they are. That, you know, if a lawyer or a witness gets up in court and starts trying to make up facts, that the opposing attorney, whether it's a defense attorney or a prosecutor, is going to point that out through impeachment, through other witnesses who will set the record straight. And once a lawyer loses credibility with a judge or a jury, it's really difficult to get it back. So I think that in a case where a lawyer, let's say a defense lawyer, is trying to manipulate the facts or stretch the truth, a good prosecutor will point that out to the jury, and the jury will hold that against not only the defense attorney but the defendant. So that approach backfires. And I think that, like I said, that there are some good facts in a criminal case, and there are some bad facts for both sides. And as a criminal defense lawyer, one of the keys to having a good trial or putting together a good defense is you have to do your own investigation, because otherwise you're just using the DA's investigator, the police, and accepting that their reports are accurate and true. You have to get your own investigator, typically a private investigator, to go out and start knocking on doors and interviewing people. And you'd be surprised at how that changes the evidentiary landscape in a criminal case.
Yeah, I mean, what he was saying is that, like, the prosecutors are obligated to just hand the facts over, and that's their case. I mean, sounds a little biased, right? Like they're completely, in other words, they're completely pure and are just handing over facts, and then the defense is like massaging the facts to, like, wiggle out of them.
Well, it's true that the defense is going to point out where a witness has a motive to say a certain thing, or a witness is biased either for or against the defendant. I mean, that puts those statements that are getting handed over into the proper context. And or maybe, the investigators didn't interview all the people that they should have interviewed. That's something else that's going to get pointed out in a criminal case. But that context is really important. I mean, it's really critical to ensuring that the trial is fair, because otherwise you would just hand the jury the police reports and ask them to decide whether the defendant was guilty or not. And that's no kind of justice system. The defendant has a right to point out motive, interest, and bias when it comes to the witness statements, and a right to do his or her own defense investigation that sheds more light on the situation.
He also said he doesn't see how someone can defend a person that they know is guilty, which probably happens quite a bit.
As as a brand new public defender, I wondered how I was going to navigate that particular part of the job. But what you learn really on day one is that you have a job to do. And if your client says, I didn't do it, I want to have a trial on the case, or if your client just really doesn't say anything about whether they did it or didn't do it, but they want to have a trial on the case, you don't have time to sit back and ponder the, you know, those types of big questions about guilt or innocence. You have a job to do, and you need to get started on that job. Your client has a right to zealous advocacy and has a right to have a jury trial, and that's the job that I signed up for. It's the job that all criminal defense lawyers signed up for. And if you're getting caught up in whether your client's telling you the truth or about those sort of morality questions, you are being distracted from what you really ought to be thinking about, which is, you know, poring over police reports, doing your own investigation, researching the law, and giving your client the best shot that he or she has to win the case, because that's what the Constitution requires.
Yeah, I feel like when people say, like, how could you defend somebody that you at least believe is guilty? I just think, like, why are you making this all about yourself? Like, you have a client who needs something, but you're making it all about what your beliefs are. Like, you're being the judge yourself. And it's like, shouldn't you let a judge or jury make this decision?
Yeah, exactly. Exactly. I mean, you have a real specific role as a criminal defense attorney. You're not the morality police, and you're not a mind reader, and you don't have a crystal ball. You just have to do the job that you signed up for, which is to try your best. There are going to be some cases that are real difficult, if not impossible to win, and you have to do your best with those, just like you do your best with the cases that are easier to defend. And the jury decides, or the judge decides, if it's a court trial at the end of the day, whether the government or when I say the government, I mean that the prosecution has met their burden of proving the case beyond a reasonable doubt.
Would you ask a client if they're guilty, or does it just not usually come up, or are you better off not knowing?
It doesn't come up with me. If my client wants to volunteer that information to me, I'm happy to talk about it. But I usually let my client steer the conversation when it comes to that particular issue. And there might be other attorneys that handle it differently. And there are many different ways to approach not only that particular part of representation, but the whole thing. I mean, that's what makes this interesting. You learn new ideas from other attorneys all the time, and other attorneys have different personalities and different styles and a completely different approach. But I would think that if I walked into a meeting with a client and put them on the spot and said, tell me if you did this or not, they might think that was more of a prosecutorial approach than a defense-oriented approach, and that for that reason, I don't really take that approach.
We had talked about, prosecution being more pure and defense kind of being more manipulative. Makes me think, though, on the other side, there's lots of cases where somebody has been convicted, and then years later, new evidence emerges in favor of the person who was convicted. And the whether that's like DNA evidence or like some witness comes forward who saw something, and the prosecutor fights to block it. And so I think, like, if they were truly concerned about justice and getting the right verdict, wouldn't they want that evidence presented and let the judge or the jury decide?
Absolutely. And there are some examples of that happening where new information comes out, and the prosecution is an open book, and they want everybody to know about the new information. I've never worked at a prosecutor's office, so I am probably not the right person to ask about the nuances around that kind of an event. But you certainly do seem to see it happen both ways. I mean, there are some cases where the prosecution does what they can to bury that new information, and other cases where they seem to be more than willing to put it out there.
Is there anyone you wouldn't defend?
No.
Okay. Well, there's a famous athlete who has been accused by something like 24 women of sexual assault.
Mm-hmm.
And I hear a lot of people say something like this. Look, I mean, if one or two, three women, you might be suspicious, maybe they're lying or something. But when it's 24 women coming forward, I mean, come on. Like, this guy is obviously guilty. Does a higher number of alleged victims, in your legal opinion, make the suspect more likely to be guilty?
It makes the case harder to defend, but in a situation like that, when you're talking about a person who's really wealthy, like that athlete you're talking about, I can't say it's out of the question that a large number of people might come forward to try and get a piece of that person's wealth. And really, at the end of the day, I think it comes down to the individual, to the accusers. And by that, I mean, at a trial, a jury gets to see and hear and evaluate the credibility of an accuser like that. And if those accusers come off sounding credible and appearing to be credible, that's going to be a real difficult case for that defendant to win, even if he is a real wealthy person. A lot of times what it comes down to is the eyeball test. If the person who's making the accusation appears to be a credible person, even after they've been cross-examined by a defense attorney, then that's a strong case against the defendant. But if that witness starts to look dishonest after they've been cross-examined and after a person has maybe challenged some of the things that they've said, then it's looking more and more like that defendant might not be guilty, because at the end of the day, the prosecution has to rule out the possibility that these people are lying. And if the prosecution can't rule out that possibility, then the defendant should win.
Yeah, I mean, does it say anything to you that, like, 2 grand juries declined to charge him criminally, so it's only a civil case, or 24 civil cases, I guess?
Well, that does say something to me, because the burden on the prosecution to get a grand jury indictment is relatively low. It's not the same as proving a case beyond a reasonable doubt. And if a grand jury declined to indict somebody, it does say something to me. It says that there might not be as much here as you might think that there is, based on media reports.
Where can people find you, and what do you want to share with people?
My office is in the Denver Tech Center in Greenwood Village. They can find me on the internet. My website is www.sheehanlawdenver.com. And I'm always happy to talk to people and help in any way that I can. I offer a free initial consultation for anybody who's charged with a DUI or a traffic or a criminal defense matter. So always happy to help out in any way that I can.
For what it's worth, if I can give you my brief impression,
Mhm.
I think I was expecting you to be a little bit more, I don't want to sound insulting to criminal defense attorneys, a little more, slick, or like, you
Mhm.
come off as very trustworthy
Mhm.
and honest.
Mhm.
And that was my first impression of you, was like, wow, I trust this guy.
Well, I get that a lot. I mean, there's a lot of attorneys that take that kind of bulldog they think that their clients want them to be that way. And I mean, you got to be authentic in this line of work. And if somebody wants a bulldog, they can go find that person somewhere else. It's just not the way I am. And most of what I do is right here in Arapahoe County or in Douglas County. I've known these judges and these prosecutors for almost 20 years. They know how I am, and that I'm just going to kind of shoot straight with everybody that I talk to. That doesn't mean that I'm going to roll over or I'm not going to put up a good fight for my client, because I do that. But it benefits me and my clients in these jurisdictions, because when I walk into the courtroom, the judge knows that he or she can believe what I'm about to tell them about my client or my client's case, and I don't have to establish credibility with them. So there is no point in me behaving like that kind of slick bulldog criminal defense lawyer stereotype.
Thanks, Michael.
You're welcome. Thank you.